Okay, good afternoon, everyone. Welcome back to Business Law 2. Today we're looking at Chapter 34, which involves the transfer of real estate by sale. So some of the major objectives to kind of go through in this chapter: understand the various forms of ownership in real property, including different categories like fee simple, tenancy in common, joint tenancy. Understand the process of finding and securing financing and closing for real estate transactions. And then at the very end of the chapter, understand how adverse possession may sometimes, transfer title in real property from one party to another. So those are the kind of like the big elements that we're going to be looking at in this chapter today. So in terms of the different types of ownership that you can have in land, there's severalty, joint tenancy, tenancy by the entirety, tenancy in common, community property. And some of this is contingent on the state that you live in. Severalty, even though that sounds like multiple parties, that actually is ownership by one person, so it's kind of an anomaly, kind of like that label. Joint tenancy is where you have two or more persons, and usually with joint tenancy, and this is the standard in Florida, there's that element or that aspect of right of survivorship. So usually with joint tenancy, that requires different unities: unity of time, so it begins at the same time; unity of title, where each party is on the deed at the same time; unity of interest, it's the same interest for everybody; it isn't parsed out through some sort of agreement; and unity of possession, everybody has equal right to possess the property. So a classic situation under joint tenancy with right of survivorship, it could be just two people that decide to own property together. It could be a marriage, could be friends, could be family members, could be an investment, doesn't matter. And so when one party passes, then the other party just assumes the total ownership interest then. So it kind of just transfers automatically, that survivorship aspect. When we talk about tenancy by the entirety, this usually is ownership between a married couple. So there's that unity of person, because in a marriage, the law looks at the marriage as being like a union of two people. So it's a singular interest, even though it comprises two persons. And so any type of sale or transfer must be a joint decision, again, unless one of the parties has passed, they've died. Tenants in common is ownership by two or more people. Again, the unity here of possession is required, but not necessarily title, time, interest. So it is possible to kind of have members, in this tenancy, meaning owners, kind of come and go. You could, one person could, sell their interest to another party or to the remaining or the existing members of that tenants in common. Community property, if you ever hear that phrase, there's only, I think, 7 states. Washington State was an example. I think Louisiana is another example. But when I lived in Washington State, Washington is a community property state, and that is in reference to married couples exclusively. So the standard under community property is property that's acquired during the marriage normally belongs to the marriage, so both parties, unless it's by a gift or inheritance, or if it's property that's owned prior to the marriage. As long as you keep it separate, then it's separate from the marriage. But you really have to take active steps to make sure that that is separate property. If you start to commingle property, then automatically it becomes part of the community property. So, like, I had some friends that before they got married, they each owned some real property. They each had a house. And so when they got married, they decided to move into one of the houses, and the other spouse decided to just rent out their house. And all the income was and the benefits of that property was kept exclusively separate. And so in that case, that other house did not become part of the community property, but the house that they moved into together of the other spouse, that ended up becoming community property because the new spouse's name was added to the deed, and so they just became kind of like the joint owners of that. So if you can keep property separate, and that also includes any type of flow of income from that property, then it can be separate. But if you commingle it, or if it's property acquired during the marriage in a community property state, then it automatically belongs to the marriage. And again, that has significance if a divorce occurs. That's the kind of like the big implication there. In terms of regulation of real estate, by government, so when we think of like state licensing, every state requires real estate brokers to be licensed with required continuing education courses. I've had students over the years that have either been like salespersons or brokers, and so every state has an interest in regulating different professions, and real estate is an example. Medicine, law, accounting, or other types of standards that professions that involve kind of regulation by state interest. It's not the federal government; it's usually a state thing. In terms of civil rights legislation, so 1968, the Fair Housing Act is probably one of the best examples of this, where it's federal law that prohibits on the federal, state, and local level any type of discrimination in property ownership based on race, color, religion, sex, national origin, disability, or family status in real estate transactions. In chapter 33, if you recall, I noted that some aspects of property ownership can run with the land, meaning that it's a burden for future owners. And in a lot of southern states, this dates back to post-Civil War. There would be language written in agreements where it limited who you could transfer property to based on race. Obviously, that's not permitted anymore, and nor should it be. But again, it's more of like how we've tried to deal with unfortunate historical aspects of racism in our society. This is just another facet of it. Listing agreements. So, if you decide, you're going to hire a real estate broker, then usually a listing agreement is entered into. I've known different real estate agents, and, it is possible to have like a non-exclusive arrangement with a broker or salesperson. Normally, they want to have that exclusivity, and so that's essentially a contract. You agree that you're going to go through this broker or salesperson for some specified period of time. It could be 60 days, 90 days, 180 days, whatever you agree to. And so, the part of that agreement gives, the salesperson or broker, the right to some type of commission, whether they find the buyer or if a buyer finds you all, doesn't matter. There's exclusive agency that's kind of folded in with that. So, it's the broker or salesperson that has, the right to, sell and receive that commission. And then, open listings, which is less common. That's where the broker only gets a commission if they're the ones that actively are responsible for the sale. And so there's less exclusivity associated with that. So if you were able to sell it on your own without the benefit of the broker, you wouldn't necessarily owe the commission. But again, a lot of brokers that I've known over the years, they really do like to kind of lock in that exclusivity so that however the property sells, if it's within the life of that agreement, that listing agreement, they're going to get their commission at that point. In terms of some of the particularities that's required by government, so like in the sales agreement, obviously buyers, sellers are identified. The real estate has to be described with particularity. You don't necessarily just list an address for property. There has to be a legal description, and for those of you that are homeowners, you kind of get what that phrase means, the legal description, because property is specifically mapped out by surveyors. And so when property is transferred, you know precisely what you are purchasing. An address is vague. Depending on what the address is, are we talking about, rural property where there's acres and acres of land? Are we talking about a subdivision and we're talking about a specific lot? Either way, you want to know what the precise boundaries are and the dimensions for the property you're acquiring. Price, signature. We know through statute of frauds, which we covered in Business Law 1, any transfer of real property has to be in writing. You cannot do that verbally. So, just recall some of the things, like I said, we've talked about in both this course and in Business Law 1. Types of deeds, the two that I have listed here, there's a general warranty deed. And so, this is where the seller warrants they have good title to convey, property is free of any encumbrances. Property is not going to be taken away by some other property, property owner. So there's this right of quiet enjoyment. There's also this idea of what's called a quitclaim deed. And this is where the seller is making no warranties. It's a simple transfer of whatever the seller has. And that could be a legitimate actual ownership, or it could be some sort of ownership that maintains some sort of defect in it. And so normally you do not want to, acquire property through a quitclaim deed process. You want to go through the general warranty deed because you want to have protections as the buyer from any other party that potentially could assert an interest in that real property. Closing process, that's where we're actually going to be officially transferring, from one party, the seller, to the purchaser. And, this is a very kind of complicated process. It usually takes hours. If any of you have ever purchased property, this is not a simple process. But, there's a lot of particularities that have to be adhered to, especially if the property is being financed. So not only are there, a lot of, rules governing, the actual written process of transferring from a buyer to a seller, but when you have a lender involved that actually is attaching a mortgage to the property because it's being financed, that's another party that has, very specific interests that have to be kind of addressed in this formal process. The last thing in this chapter is adverse possession. And, as a public policy, so like big picture in the United States, we like the development and use of land. We do not necessarily like the idea of land just being acquired and then just sitting there and doing nothing with it, although that does happen sometimes. We like the idea that land is going to be used and developed, so whether you're creating a business, if you're, building homes, you're doing industrial activity, you're going to mine the land, whatever it is, we want you to use the land. And that's just a public policy in the United States. That being said, if there is a landowner that is just doing nothing with the property, and, let's say that they're not even monitoring the property, this happens less in urban and suburban areas because, obviously people, they're going to use their land in those settings. This is in more rural areas, in particular, a lot of areas out west. One area where there are still cases that pop up from time to time involving adverse possession would be like in Montana and Alaska, so more remote parts of the United States. And the theory here is that if you have initial trespasser, because that, it's someone who's not on the property in terms of a titled owner. So this person just wanders onto your property. If they start occupying it and their intent is to take possession, every state has different rules, but at some point, if they satisfy all these elements, and I kind of will just briefly discuss them. So, the person claiming the title by adverse possession must assert that they have the right to possession, even though it's hostile, meaning that they're a trespasser. They have to actually possess the property. It has to be open and notorious. They can't be hiding. They have to be out in the open. To the extent it's out in the open. I mean, some of this stuff is in in the wilderness, but I mean, they can't be concealing their use. It has to be continuous. You can't use it for like every summer, and then come back the following summer. It's got to be around, around the calendar year, not interrupted in any way, explicitly continuous. And it has to be exclusive. Exclusive means that you prevent others from using it, so you are acting like an owner, even though initially you're just a trespasser. And if you do it for the statutory period of time that's required by the state where this property is located, then you can actually file with the assessor's office and you can claim ownership of that property. So the rule in Florida is 7 years. If you satisfy all of these elements in Florida for 7 years, then you can actually stake a claim on this property. Again, the idea is that we want to make sure that, property is being used and developed. And, there are some property owners in the United States that they have all this land, maybe in a rural county or somewhere out west. Maybe they own thousands of acres and they're just not doing anything with it. It's just wilderness. And, I mean, these are not national parks. That's different. There is some property that we set aside for non-development. This is private ownership of land that we're talking about. Uh, and uh, and so I give some examples. Ted Turner, the billionaire who started CNN, for years he has been the largest private landowner in the United States, and he's an interesting character. He's had this goal for years. He's wanted to ride a horseback on his own property from the Canadian border to the Mexican border. And so he's trying to acquire like different tracts of land, in Texas, New Mexico, Colorado, Wyoming, Montana, all up and down, north and south in the western United States. And besides his kind of like eccentric goal of riding his horseback on just his own property, the the challenge for someone like him is he literally owns hundreds of thousands, if not millions of acres of land, and you've got to be able to manage that. If he's derelict in any way, and this is where you can have agents, property management agents, kind of like survey your land periodically to make sure that no one is kind of like again trying to adverse possess it. That is a burden that goes with ownership in land in such large amounts. One last story. There was a case in Alaska, this was years ago, where the landowner owned, I think it was around 500 or 1,000 acres. So this landowner had a huge tract of land, and a trespasser, kind of basically went on his property, cut down trees, made an old-fashioned log cabin, and was living, on that property. And they were satisfying all these elements. The goal was to take the property. They were possessing it. It was continuous, open notorious, exclusive. And after the statutory period in Alaska, they wanted to claim all of the property, so all 500 to 1,000 acres. The problem with that is that they weren't actually using all of those 500 or 1,000 acres. They were only using about 2 acres. So, you're only allowed to adverse possess what you are actually possessing. You don't get the entire ownership tract. So there are restrictions that are in place for adverse possession. It's an interesting area of the law. It's, it's odd because we normally don't endorse theft, but in this case, we think it's a greater public policy benefit if people are going to actually use land as opposed to leave land in its raw state undeveloped. So this is a very narrow exception, and there's a lot of rules that you have to adhere to in order to successfully adverse possess, and actually take ownership of property from another party. Anyway, as you have questions, please feel free to message me anytime. Call, text, email me. But I hope each of you have a good, productive rest of the week, and I'll be chatting with you all online. Thank you so much.